Could Britney Spears be ordered to pay the $650,000 in attorney's fees that Lynn Spears is seeking from her? Well, let's break it down. My name is Christopher Melcher. I'm a California attorney, and I find this fee request to be outrageous, not just by the amount that's being sought, but the fact that they have such little to show for it. And in this video, we're going to fact check the claims that Lynn is making. In May of 2019, Lynn hired this firm called Jones Swanson in Louisiana to represent her regarding concerns she had about the Britney Spears conservatorship. And right there, it makes no sense. The conservatorship is a California action where California law would apply. A Louisiana law firm would know nothing about California law and is not even entitled to practice law in the state of California. Now, sometimes we'll hire an out-of-state counsel to assist with a case if they have substantive knowledge in a particular area, but Mr. Gladstone admits that he has no knowledge of conservatorships. In the fee application, Mr. Gladstone admits that he had to get up to speed on conservatorship law and probate rules. Well, there's no reason for his involvement if he doesn't know the area of law and is not even a California lawyer. Nevertheless, he wants to be paid $800 an hour and his partner Lynn Swanson $700 an hour. That is a very high rate for any lawyer to charge, let alone someone who's not even in a large city. Mr. Gladstone does not say that he regularly receives this rate from any paying client, nor does he explain how that rate is reasonable for services performed by Louisiana counsel who's not a specialist in probate law. Law licenses are issued state by state. And to be a licensed attorney in California, you need to go to law school, take a test, pass a background check, and do continuing education. And the unauthorized practice of law in California is a crime. There is an exception called pro hac vice, which is Latin for this occasion, which was used by Mr. Gladstone to get approval of the probate court to make an appearance in this action. He filed that application in May of 2019 and it was granted. But the condition was to have California counsel attached to the case who would oversee or participate in these proceedings. So California attorney Yasha Bronstein was brought into the case to be that California counsel. Well, right there we have duplication of efforts. We have a Louisiana attorney who's not authorized to practice law in California and doesn't even handle conservatorship cases, who for some reason wants to be involved in this California action, but as a condition needs to hire California counsel. So now we have two attorneys when we could have one. Mr. Gladstone states that he has a fee agreement with Lynn Spears that allows him to seek compensation against the estate of Britney Spears if allowed by statute, and that any money recovered would be credited against the amounts that Lynn owes for his services. And that is exactly what he's doing. He's now filed an application for fees, wants Britney to pay for that, and we're going to discuss at the end of the video whether there's even any legal authority for that application. There's a summary of the services that Mr. Gladstone's firm provided in this fee application. 441 hours of time was spent talking to Lynn Spears. That is an amazing amount of time to be on the phone with anyone. And I don't know what they could possibly have been talking about for 441 hours. Remarkably, only 65.5 hours were spent preparing any court papers. And no application was filed by Lynn Spears to terminate the conservatorship. The California attorney, Yasha Bronstein, only spent 3.7 hours preparing court papers, but they want $650,000 for their efforts. In her fee application, Lynn Spears and her attorneys claim that they were instrumental in helping with the conservatorship. That I agree with. Lynn Spears was instrumental in starting the conservatorship. In February of 2008, Lynn Spears signed a declaration in support of a petition for conservatorship to be placed upon her daughter without any notice at all. Lynn Spears was part of the effort to convince the court to deprive Britney Spears of her rights of due process under the law. And not long after, Lynn Spears claimed that she was proud of the work that Jamie Spears was doing as a conservator. In her request for fees, Lynn Spears and her attorneys take credit for having Bessemer Trust appointed as a professional fiduciary to serve alongside with Jamie Spears as what they call a check and balance. They claim that Bessemer was appointed as a result of their direct efforts and that on June 30, 2021, the court ordered the appointment of Bessemer Trust. But that is only half true. Bessemer Trust was appointed by this order on June 30, 2021, but the order makes clear that Bessemer Trust would have no powers without letters of conservatorship being appointed. Lynn Spears and her attorneys completely botched this by not following up to ensure that Bessemer Trust was properly appointed. These letters needed to be done. Anyone with any level of probate experience would know that, but yet they waited over 6 months and did nothing, at least in any court filing, to ensure that the court would actually have Bessemer Trust serve alongside Jamie as intended. No one did that. They completely dropped the ball, and Bessemer Trust therefore never took any action at all. And it was only days after this June 30 order that they tout in the fee application that the court relieved Bessemer Trust when it resigned and made a finding that Bessemer Trust never took any action at all as co-conservator. So Lynn and her attorneys get zero credit for Bessemer Trust. In fact, they failed to protect Britney Spears by not following up on the appointment of Bessemer Trust. Lynn claims that she assisted Britney when she found out that she was in this medical facility against her will. Well, there's a video of Lynn being asked how Britney was doing in this medical facility, and she said, "Wonderful." Let's take a listen.
Hey Lynn, how are you? How's Britney doing? Was Britney held against her will, Lynn? How's she getting on now?
Wonderful.
Lynn and her attorneys claim that they were stonewalled, that they were interfered with by Jamie and his attorneys, and even Britney Spears' court-appointed attorney, Sam Ingham, didn't help. Well, if that's true, why didn't Lynn Spears file her own petition to terminate the conservatorship? She had the right to do so as an interested party. Many people were wondering when an interested party would show up before June 23 or July 14th to terminate this thing. Lynn never took that step, and Lynn had incentive for this to continue on. According to Jamie Spears, $150,000 a year in housing expenses were being paid by Britney's estate for Lynn that totaled $2 million. There's no reason why Britney's estate should have paid any money for Lynn's housing. Jamie should have never used Britney's money that he was a custodian of to pay for somebody else's living expenses, let alone someone in an estranged relationship. And if Lynn received all of this money, she was profiting from the conservatorship and would have a reason for it to continue. There was a letter that Britney hand-delivered to her mother in 2007, which is reported to have been a letter asking her mom to stay out of her life. Britney walked away from delivering that letter looking very confident and not like somebody who needs a conservatorship. And it was only 1 year later that the conservatorship was placed on her with Lynn's assistance. Lynn does not mention her relationship with Lou Taylor or any criticism of Lou Taylor in these documents. The only mention in the fee application is of TriStar's management role and whether that was needed anymore. We have heard serious allegations of a surveillance operation being conducted against Britney Spears and other abuses, and yet Lynn has no criticism at all for Lou Taylor or any question of whether Lou Taylor was involved in this or not. That relationship goes back quite a while. Lou Taylor acted as a spokesperson for Lynn in 2008 when Lynn was being questioned about an automobile accident that she was involved in back in 1975. Lynn was driving her vehicle, coming around a bend. There was a boy on a bicycle, and she struck and killed that boy. When Lynn was questioned why she had never expressed condolences to the family of that boy after so many years, her spokesperson, Lou Taylor, said, "As Lynn rounded the curve, she could not avoid the boy in the street as there was oncoming traffic in the opposite lane." I would hope that if any of us faced that terrible choice, that we would drive into the oncoming traffic rather than running over a child. Lou Taylor should not be a spokesperson, and I hope that it was Lynn's money that was being used for that role and not Britney's. Lynn Spears and Lou Taylor appeared together at the CMA Awards in Tennessee in 2014. They obviously had a close relationship, and we see no criticism at all by Lynn of Lou in her fee application. So is there any legal authority for this fee application? Lynn goes under California Probate Code sections 2640 and 2642 as her statutory authority for fees. But those statutes allow for fees to be paid for an attorney for a conservator. And Lynn was never a conservator. Those statutes make no mention of a parent of a conservatee receiving fees. No case law was cited in the fee application for their proposition that an interested party could be paid fees under a statute that allows only for the conservator's attorney to be paid. Lynn also made a pitch for what are called private attorney general fees under California Code of Civil Procedure 1021.5, and this is a crazy stretch on their part. She says not only did she benefit her daughter, but she had benefited all conservatees in the work that she did in this case. That is complete nonsense. I see no benefit that was derived by Britney for the work that Lynn's attorneys did, and certainly not the whole class of conservatees in California. Now, as to the reasonableness of these attorneys' fees, Mr. Gladstone says that his firm racked up $840,000 in attorneys' fees, but he's feeling generous and he's going to give a 40% discount on that bill. He's seeking only $504,000 for his fees without explaining why the 40% discount is necessary if those fees that he incurred are reasonable in the first place. The fees by Yasha Bronstein's firm are sought at $146,000. No billing statements are attached, not one of them. So we can't tell if they issued regular monthly billing statements and to get the detail of all this work that they claim they did. It's a huge omission. The court can't really look at the reasonableness of these fees without seeing the billing statements. I don't believe these fees are reasonable or authorized. I don't see any meaningful benefit that Britney received from it. She did not ask for her mom's help. Her mom never filed a petition to terminate. Her mom decided to hire an attorney who's not even licensed to practice in California and does not do probate law. The court should deny this fee application and make Lynn pay her own fees. I hope you enjoyed the video, and I'll see you next time.